Yes, Your Honor.
Okay.
My apologies.
Attorney Branch?
Sure.
Okay. This is the people of the state of Michigan versus Devin Boatwright, case 2355761. Mr. Boatwright is charged with count 1, stolen property, receiving and concealing a motor vehicle. Count 2, motor vehicle unlawful driving away of an automobile, set for a probable cause conference today. Appearances?
Good morning, Your Honor, and everyone in the court. Peter Lewinsky appearing on behalf of the people, P84448.
And William F. Branch, P-26846, attorney for the defendant.
Mr. Boatwright, unmute your device and state your name, please.
Devin Boatwright.
Thank you. In my understanding, Attorney Branch, that your client will be waiving his exam today?
Yes, that is correct.
Okay, any objection from the people?
No objections from the people, Your Honor.
Okay, Mr. Boatwright, keep your device unmuted. I have to talk to you and ask you some questions.
Yes, ma'am.
And turn your camera on.
Oh, okay. One moment.
Okay, Mr. Boatwright, is it my understanding that you're going to waive your exam today?
Yes, ma'am.
You understand you have a right to a preliminary exam?
Yes, ma'am.
And that if you were to demand an exam today, the people would have to show at the probable cause standard, which is a much lower standard than the probable beyond reasonable doubt standard, but still a standard, that the charges that I read off just now were committed in the city of Detroit and that you likely committed those crimes. Do you understand that?
Yes, ma'am.
And that by waiving your exam today, the people do not have to prove that. Do you understand?
Yeah.
You say yes, ma'am. I think you did.
Yes, ma'am.
Okay, and knowing that information, you still wish to waive your exam?
Yes, ma'am.
Did anyone force you or threaten you to waive your exam?
No, ma'am.
Okay, did anyone promise you anything to waive your exam?
No, ma'am.
Okay, I find your waiver to be freely, understandingly, and voluntarily given, so I will have you bound over to Third Circuit Court, that's Frank Murphy Hall of Justice, for an arraignment on the information date of March 24th at 9:00 a.m. and bond is continued.
Thank you very much, Judge.
Thank you all both. Have a good day.
Okay, thank you. Mr. Boatwright, we're all set.
You too, Your Honor. Have a good day. Thank you.
Thank you.
Bye-bye.
Any other attorneys ready on their case?
Should be ready.
Okay, that's on William Welch.
That is, and I'm standing in for the co-defendant on Mr. Williams.
Okay. Okay. William. Terry Williams. William Welch on. Okay. Okay, Mr. Williams and Welch, go ahead and unmute your device.
Hello?
Yes, just unmute your device. I'm getting ready to call your case.
Okay.
This is case 2355520, the people of the state of Michigan versus Terry Williams Jr., who was defendant number 1, and William Blake Porter Welch, who was defendant number 2. Defendant 1 and 2 are both charged with count 1 criminal enterprises conducting. Count 2, both defendants charged with stolen property, receiving and concealing a motor vehicle. Both defendants are charged with count 3, attempted larceny from a motor vehicle. Defendant 1 is charged with count 4, count 5, count 6, count 7, count 8, count 9, all which are stolen property, receiving and concealing a motor vehicle. Count 10, defendant 1 is charged with weapons, firearms possessed by a felon. Defendant 1 is charged with count 11, weapons, felony, firearm. habitual offender for the notice for defendant one. Today's day set for a probable cause conference appearances.
Good morning, Your Honor. Gregory Blackburn on behalf of the people.
And good morning, Your Honor. Jason Melowitz, P61242 on behalf of Mr. Welsh. And I'm also standing in for the attorney of record, Joseph Arnone, on behalf of Mr. Williams, who has no objection to me standing in today.
Okay, and Mr. Williams, can you state your name, please?
Terry Williams.
And Mr. Welch, can you state your name?
William Welch.
Okay, any discovery issues? I don't think so, but are there any?
Judge, there's not any issues per se. I did receive some information from the officer in charge of the case, I believe 2 days ago, that he does have a lot of additional video discovery. It's about 240 gigabytes. So I have put defense counsel in contact with him, and they are going to set up a meeting so that they can exchange that information, which we will do, or they will do well before whatever exam date we set today.
Okay. So let's see here. We are in the week of March 27th.
Your Honor, because of the I guess I would say that the large amount of discovery that I haven't seen, speaking with counsel as well as for the co-defendant and the prosecutor, we were asking if the court would consider moving this out until April, perhaps April 13th.
Okay, that's fine. Oh, that was the email that I agreed to. Yes, I remember now. Okay. All right, yes, April 13th is fine. Let me make sure. I don't think there's anything on the calendar. But no, there's nothing on the calendar. What time? I'll have 9, 9:30, 10, 10:30 open.
Judge, I would prefer later in the morning if it's okay with counsel. I still have a circuit court docket that I may need to attend to, so later in the morning would be great.
I'm okay with whenever that morning, Your Honor. So 10:30.
10:30, and if you're a little late, that's fine.
Thank you, Judge.
Okay, so we set in person to Mr. Welch and Mr. Williams. Your preliminary examination has been set for an in-person exam. And
Okay.
that day, April 13th, right?
Correct.
At 10:30 a.m.
Okay.
Anything else?
Judge, just on behalf of Mr. Welch, I know this argument was made last time. The court modified his house arrest provision. He's been on tether. There is no violations. He does not have the felony firearm charge as Mr. Williams has. I would ask the court to consider removing Mr. Welch's tether.
Anything from the people?
Judge, I'm not terribly familiar with this case yet. I did inherit it a couple days ago, so I just based on the charges, I guess I would just leave it in the court's discretion.
And this is for Mr. Welch, correct?
That's correct.
No, I'm going to keep the tether on based off of the charges here. I did lift the house arrest, so he can move freely about it, but in the event that something does happen, I do want to be able to know where he was at the time.
Understood.
Anything else?
Nothing further.
All right, you have a good day, all of you.
Thank you.
Thank
Judge.
All right. Thank you.
Hey, Governor. I think my client is on Zoom.
You just need another date, right?
Yeah, I just need another day. Yeah.
Another date? Or-
No, we can set it for a preliminary examination.
Okay, that's what I would like.
Yeah.
Who did that on the phone with you?
Oh, you know what, Judge? I was coming down anyway. I have an exam downstairs, so
Come visit.
I come visit.
Okay, what's your client's name?
Javante Jones?
Okay, we're on the record as the people of the state of Michigan versus Javante Jones, 2355056. Mr. Jones is charged with one count of weapons carrying concealed set for a PCC today. Appearances.
Good morning, Your Honor, and everyone. Peter Kowinski appearing on behalf of the people, P84448.
Judge, good morning, ma'am. Please, this most honorable court, Benson J. Tucson, 58609 on behalf of Mr. Jones. He appears today by Zoom since they're having his hearing earlier.
Mr. Jones, can you state your name, please?
Javante Jones.
Thank you. Good morning.
Good morning.
Your Honor, I know today is day 7 for BCC. What we like to do is set this for an examination.
Okay. I have March 20th as the early date.
Judge, I have a trial in Frank Murphy on A1 case starting on the 20th, which will probably last to the 22nd or early 23rd. I can be back on the 24th for court has 24th available.
Have it 10 o'clock.
10 o'clock is great.
March 24th, it's 10 o'clock a.m.
Judge, thank you.
You are welcome.
Good to see you.
Good seeing you too. Mr. Jones, your exam has been set for in-person, March 24th at 10 a.m., 36th District Court.
Okay.
We're all set. You can log off. Have a good day.
Everyone be safe out there. Take
Yes.
care.
Carvalho,
Yes, Your Honor.
good morning.
Good morning.
Are you ready on your case?
I have Jonathan Brown. I don't know if he's showing up on Zoom. He was supposed to put a waiver on the record, but I'm trying to call him and he's not answering.
Okay, let me call a couple other cases and I'll come check back with you.
Thank you.
Attorney Tiago,
Yes, hello. I'm ready on Darius Walker. He is on Zoom.
okay, thank you. This is the people of the state of Michigan versus Darius Walker, case number 2259071. Mr. Walker, Darius Javon Walker is charged with count 1, weapons carrying concealed set for a probable cause conference. Appearances.
Good morning, everyone in the court. Peter Kowinski appearing on behalf of the people, P84448.
Rebecca Chiappo, P62311, on behalf of Mr. Walker, who's appearing via Zoom.
Mr. Walker, can you state your full name for the record, please?
Darius Walker.
Okay, and I believe, let's see here, are there any issues with discovery?
No issues with discovery, and we do have an exam date already scheduled. So I guess we're fine for now.
Okay, so that's the 17th, correct?
Yes, 10:30 a.m. Is that right?
Yes.
Okay.
All right.
Thank you so
Mr.
much.
Walker, you're welcome. Mr. Walker, your exam is set. I think I told you already, but I'll tell you again. March 17th in person at 36th District Court, 10:30 a.m., okay?
Okay.
You are all set. You have a good rest of your day.
All right.
Good morning, Your Honor.
Good morning.
I was in a breakout room with my client and it kicked me out on accident. I wanted to know if I could get back in.
Is your client the one in custody?
No.
Martell Watkins?
Yes, correct.
I don't see him on here.
Oh, maybe he left.
Oh, he has an iPhone. He's in the breakout room. You just have to go back in there.
Yep.
Attorney Matthew, good morning.
Good morning, Your Honor.
Your Honor, I don't see my client. I don't think they brought him over from the jail.
Oh, he wouldn't be brought over for a PCC.
Oh, well, would he be on video for PCC?
Yes, I'm trying to see who the person is in Wayne County Jail. The camera's not on right now.
Excuse me, Judge, that's Attorney Brown's case.
I think I see what happened. He was given a personal bond here, but it looks like he's on a probation violation hold, so he never got out.
Okay.
We may have to put it over.
to waive his presence, or do you want to wait to see if he's brought out?
Your Honor, I'll waive his presence. I don't think they're gonna bring him. I don't think anybody knew he was up today.
Okay. This will be ready Wednesday. This is case 1956101, the people of the state of Michigan versus Reggie Winston. Mr. Winston is charged with 1 count of controlled substance delivery, manufacture of cocaine, heroin, or another narcotic less than 50 grams, with the second or subsequent offense notice, and also a habitual offender second offense notice. Today's the day set for a probable cause conference appearances.
Good morning, everyone in the court. Peter Kowinski appearing on behalf of the people, P84448.
Good morning, Your Honor. Romy Mezzi, P68245 on behalf of Mr. Winston. Your Honor, I'm gonna waive his presence.
Okay. And you have discovery?
I don't, Your Honor. I needed the discovery on this case. I'm also gonna need to confer with my client. I thought he was out on a personal bond. If we can set this matter for just another PCC, maybe in a week.
Would you like to also have an exam date set as well, just so that it won't be so far out a week from now?
Sure. If we can set the, I don't know if you can give me a PCC for the 17th and maybe set an exam right after that.
That's fine. So we'll do a PCC, let's do 9 o'clock, and then exam date, we can do, can you do that week, the week of the 27th?
The week of the 27th, let me see. I can, I think the only day I have is the 30th, Judge.
That's fine.
Okay.
9, 9:30, 10, or 10:30?
Whatever the court prefers. 9:30 will work for me.
9:30 is fine. If for some reason that date needs to be changed, I will, of course, change it.
Sounds good. Thank you, Your Honor.
You're welcome. Anything else?
No, have a good weekend.
You as well. Thank you.
Take care. Bye-bye.
Okay. Anyone else ready?
Ready on Marquise Thomas.
Okay, case number 2355761, the people of the state of Michigan versus Marquise Thomas. Mr. Marquise Thomas is defendant number 2 and charged with count 1, stolen property received and concealed in a motor vehicle. Set for a probable cause appearances.
Good morning, everyone in the court. Peter Kowinski appearing on behalf of the people, P84448.
Good morning, Your Honor. Maurice Davis, P76203, appearing on behalf of Marquise Thomas, who's present, appearing via Zoom. Mr. Thomas, state your name for the record.
Mr. Thomas, unmute your device and turn on your camera and state your name.
Marquise Thomas.
Thank you. Any discovery issues, Attorney Davis?
I haven't received it yet, Judge. So I'm asking the court to set this over for another PCC for now, so the prosecutor has an opportunity to furnish the discovery.
Let Mr. Kowinski check to see if it's been sent.
Yeah, I'm seeing that paper discovery has been sent on March 3rd. And let me double check for the digital. Give me a moment.
Okay. If he sent discovery on March 3rd, I wasn't retained until a couple days ago. He may have sent it to previous court appointed counsel or something.
Okay, so Mr. Kowinski, can you just send over discovery to?
Sure, I can resend it. That's no problem. I can do that right now.
Okay. I'd like to set this for an exam. If you want Attorney Davis another PCC in a week, I can do that, but I still like to set an exam date.
Okay, yeah, let's do that.
Okay. So for a PCC, we can do next Thursday, on the 16th.
Next Thursday, that's fine.
9 o'clock.
We do 10:30.
9 o'clock. You said 10:30 for, well, that's fine, it doesn't matter, we'll be here.
Okay.
And then for an exam day, I have the week of March 27th.
We're March 27th.
Yeah.
The 28th.
I'm sorry, which
Is that for the exam?
for the exam, yes.
Okay, cool.
Well, I didn't set the date for the exam yet.
Oh,
The
okay.
28th looks fine.
March 16th at 10:30. And then we said the 28th for the exam?
Yes,
Okay, 9:30 or 10:30?
10:30.
Okay. All right, so I will have to see whether Mr. Boatright, I can get with his attorney. Okay, so it's been set for now. Mr. Thomas, you can appear on Zoom for your next PCC on March 16th at 10:30, okay?
Yes, ma'am. Yes, Your Honor.
Anything else?
No,
that's all.
ma'am.
Thank
Okay.
you.
I gave you a break. I didn't know it was.
Oh, that's what you gave it back to me for.
Excuse me, Your Honor.
Yeah.
What's the name of the attorney on the Marquise Thomas case?
Grace Davis.
Davis, that's right.
And I just realized codefendant just wait.
This is co-defendant,
Boatright.
oh, right, that's right.
Okay, so we don't have to worry about coordinating that date. Thank you. All right, Saba? Saba? We ready on Watkins?
Yes, ma'am, Your Honor.
Yeah.
To the person in the Wayne County Jail, do you have something you want to say to the court? You don't have an attorney present right now, so we're not calling your case.
No, Judge, that's just, that's Attorney Brown's case. Client.
You did Brown?
You gave him a date. That's the one I did before you got on the picture.
Okay, so yes.
March 27th at 10.
And that's Brad Shaw, right? Mr. Bradley, your attorney gave you or got you a date for your preliminary examination. It was just a date set today, so you don't have to be called on the record. So your exam day will be March 27th at 10:30 a.m. It'll be at 36th District Court.
Okay, thank you.
You're welcome. You have a good day.
You too, ma'am.
Thank you. Okay, people of the state of Michigan versus Martell Watkins, case number 2355264. Mr. Watkins is charged with 1 count of weapons carrying concealed set for a preliminary exam, for a PCC this morning. Appearances.
Alexander Kirk on behalf of the people, 886-286.
And good morning, Your Honor. Brian Monzeva on behalf of the defendant, PA3365. Mr. Watkins is here on Zoom currently. If you're ready, Mr. Watkins.
We can't hear, your audio is broken up.
I'm sorry. Mohammed Seva, PA3365, present on Zoom with Mr. Watkins. Mr. Watkins, please present yourself to the court.
Hello, Martell Watkins speaking.
Okay, good morning.
Good morning.
Do you have discovery on this case?
We do, Your Honor. We would like to set a preliminary exam date.
Okay. Let's see, we're at March 27th that week.
March 27th.
The week of the 27th, if you have a day you'd like to pick, that's fine.
Let's see here. The week of the 27th, maybe that Monday, 9 a.m.
That works?
Okay, thank you. Mr. Watkins, preliminary exam will be March 27th, 9 a.m.
March 27, 9 a.m. Okay, thank you.
In person, Mr. Watkins, you understand?
Excuse me?
In person at 36th District Court.
Okay.
Anything else?
No, Your Honor, thank you.
Okay, you both have a good day.
You too.
Thank you. You did Preston already, right?
Yeah. No.
That's Roberts. I have the books back here. Don't worry about getting Roberts. You can wait all for. I'll need to go.
No.
Okay.
No, okay.
It's late, but we have some dead time we can do. Later. Mr. Kirker?
Yes.
Can you handle this mic? Okay. Okay, we're on the record. This is the people of the state of Michigan versus Dana Link, case 2355484. This Link is charged with count 1, assault with a dangerous weapon, felonious assault. Then they set for a preliminary examination appearances.
Alexander Kruger on behalf of the people, P86282.
Thank you, Brian. Thank you, Mr. Sarah Robertson. Dana Link stands to my right. Ms. Link, can you state your name for the record? Dana Link. Thank you. Good morning. Good morning. Understanding that Attorney Robertson, your client's going to wait today? That's right. Any objections from the people?
No objections from the people.
Okay, Ms. Link, I'm going to ask you a few questions, okay? Yes, ma'am. Make sure you speak up. Okay. It's your wish to waive your exam today? Yes, ma'am. You understand you have a right to an exam? Yes. And then if you were to demand that exam today, the people will have to show at the probable cause standard, which is the lower standard, we still have to show at that standard that the crime I just read off was committed in the city of Detroit, that you likely committed that crime. Yes. And that by waiving your exam, you do not, or the people do not have to prove that today. Yes. You understand that? Yes, ma'am. Okay, and knowing that information, you still wish to waive your exam? Yes, ma'am. Did anyone force you or threaten you to waive your exam? No, ma'am. Did anyone promise you anything to waive your exam? No. Okay. I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Third Circuit Court, that's Frank Murphy Hall of Justice. For the rate on the information 2 weeks from today, it'll be March 24th at 9:00 a.m. Okay? Yes, ma'am. Anything else? No. All right, thank you all. You have a good weekend. Can I talk to you before you do? Sabree, is there a Jonathan Brown out there?
Brown. Oh, man, I have to check in yet.
Okay.
Let me go. Screen it.
person, the attorney at Washington Milton, it's last name is King.
I don't know.
Martha, you said, I'm sorry, what's the defendant's name? Last name Washington. Oh,
Oh, Jonathan Brown, man.
Okay, thank you.
I have it, James King, is that helpful?
Yes.
Okay.
To the gentleman who just logged on from Wayne County Jail Division 2, can you state your name, please?
Reggie Winston.
Winston. Excuse me. Okay, thank you. Mr. Winston? So your attorney has already set dates for you, that's all we did today. Your date, we have another probable cause conference, and what was scheduled today, but adjourned to next Friday, so that, be provided to your attorney, so that your attorney can talk to you about how he wants to move forward and how you want to move forward with your case. And then there's a date set for your preliminary examination. It'll be March 30th at 9:30. But first, we'll get to next week. It'll be 1 week from today at 9 o'clock. You'll still be on Zoom for another probable cause conference in which any preliminary issues will be discussed with your attorney and the prosecutor in the court. Okay?
Okay.
So you didn't miss anything that day. So you're all set for today, Mr. Winston?
I can't hear you.
You're all set for today. We just said,
Okay. I'm here.
okay, Preston. Okay, we're on the record as the people of the state of Michigan versus Justice Preston, 2355327.
Yes.
Justice Preston is charged with 1 count of weapons carrying concealed. Set for a probable cause conference. Appearances.
Good morning, everyone. Peter Kowinski appearing on behalf of the people, PA4448.
Good morning, Your Honor, Madam Clerk, Madam Court Reporter, Jonathan Roberts, P86428, on behalf of Mr. Preston, who is present via Zoom. Mr. Preston, could you please state your name for the court?
Justice Creston.
Thank you. Any discovery problems or issues?
No discovery issues. We are looking to set an exam date today.
Okay. So we're at March 27th that week, any day, and that week that works best. Let me know.
The 27th would work. I just have a matter at 8:30, so if we could set it at 9:30.
Yeah, there's an exam at 9, so you'll be next 9:30.
Thank you.
Okay, Mr. Creston, your preliminary examination has been set for March 27th at 9:30 a.m. in person at 36th District Court. You understand that, Mr. Creston?
Yes.
Okay, anything else?
That's all from defense. Thank you.
Nothing from the people?
Just to make sure the date is March 27th, correct?
Yes.
Nothing from the people.
Okay, you're all set, Mr. Creston. You can log off.
Thank you.
Have a good day. Okay. back to. Attorney Hanabala,
Yes, Your Honor.
we're getting ready to start the exam.
Your Honor, in my case, I just spoke with my client. He still cannot make Zoom. So I'm asking that the court accept it by way of a speakerphone. He can dial in and put it on the record if the court so pleases.
That's fine.
May I have the number to give him so he can dial it straight to the court, or do you want me to do the patching up?
I'll give you the number. Do you know how to use the chat function? I can just send it to you in the chat.
I will do it in the chat, Your Honor. I will wait for it.
Okay. So the two sets of numbers, you have the dial-in number and then the Zoom ID.
Okay, he has to dial two separate numbers. Okay.
Yeah, so the first number is as if you're dialing, since he's on the phone, I'll send you that number now.
Yes.
That's the phone number I just sent, and then the Zoom IDs follows. When they ask for the Zoom ID, to put in the last 10 digits.
And then basically the Zoom ID is the same ID that I used, right?
Correct.
Okay. Okay, I get it. I get it,
Yep.
Judge. He will be on in the next few minutes.
Okay, thank you.
Yes, sir.
Okay, this is people state of Michigan versus Jamar. That is Fisher 2355333. Mr. Fisher is charged with count 1, police officer assaulting, resisting, and obstructing, and count 2, which is a misdemeanor retail fraud. Today's day set for a preliminary examination. Appearances.
Good morning, Your Honor, Madam Clerk, Madam Court Reporter, opposing counsel, and everyone. Peter Kowinski appearing on behalf of the people, P84448.
And good morning, Your Honor, Madam Clerk, Madam Court Reporter Jonathan Roberts, P86428, on behalf of Mr. Fisher, who is present in court today. Mr. Fisher, could you please state your name for the court?
Jamar Fisher.
Okay, is everybody ready to proceed?
One preliminary matter, Your Honor. I believe that there was a discovery order that was signed on the 8th, Wednesday. It was granted in full, which was a motion to dismiss or compel discovery. We were missing several pieces of digital discovery that were required as part of the initial discovery, including body-worn camera footage of the officers who first responded to the call for the alleged incident. We are missing the use of force report that was completed for Sergeant Brent Sir. We are missing the interrogation, the video recording of the interrogation of Mr. Fisher. We are missing the recorded statement on video of the complaining witness, Muhammad Al-Masmari. We are also missing, to the extent that it exists, the video recorded statements and the written statements of the interrogation of Jeremiah Fisher, who is a co-defendant in this case. The order states specifically those things should be disclosed to us prior to today. I had a chance to speak with Mr. Kowinski. It sounds like there was not a conversation with the OIC between when the discovery order was signed and today. All I was given was a file yesterday, which was duplicate discovery. So there was no additional discovery in the file, just the same zip. I do believe that Mr. Kowinski has reached out to the OIC today after I let him know. However, the order is binding. I cannot ethically proceed today because I don't have key information to respond to whether or not the use of force, whether or not the order itself by Sergeant Sir was legal. That's why we have these outstanding discovery items in the motion. I do believe the motion was received by Mr. Kowinski. So to the extent that it was received and there was no follow through, I would be requesting a dismissal without prejudice today. Insofar as the order was signed and granted in full, that this case gets dismissed or the discovery is produced before today.
Mr. Quincy, you have.
Yes, Your Honor. So in all honesty, I may not have seen the order for discovery in this case. I sent the discovery, what I thought was all the digital discovery that existed yesterday, in preparation for today. I just been probably swamped it the last few days, that I just got around to it yesterday, and I sent what I thought was all the digital discovery. And apparently it's been brought to my attention this morning. That's not everything. So I did have a chance to speak with the OIC. He was here. He gave me his number, and I did say that there may be a potential discovery issue. Defense attorney saying he didn't get everything. So just to be sure, would you be able to resend all of the digital discovery? And as soon as I get it, I would definitely do my due diligence to send it to Mr. Roberts.
So my question is, body worn, there's several things, use of force report, does that exist?
To be honest, I have no idea.
As far as everything, you have no idea.
What I said yesterday on evidence.com, I thought that was all the digital evidence that exists. Was not sure that there was more that was missing.
Okay, and the OIC is not here today?
I believe he left, but he left me his card. I do not know if he's still here. I think he probably left because he had other stuff going on. But I did ask him to see what you can find on this case and re-upload and send me an email, and I would send it right away.
Mr. Quincy, I know this is not necessarily, you, this is day 2 that you've been in here, but do you know why all of the videos aren't sent over initially?
To be honest, I'm not sure. Normally it is my assumption that when the officers send all the evidence, they send everything that exists.
I would like to hear from the OIC.
Would it help if I go out to see if he's there?
Yes.
Okay, give me one moment, Your Honor. And I apologize for taking up the court's time.
That's fine, and then if he's not out there, you give him a call and ask him if he has the following information or if he knows if it exists.
Okay. Okay, yeah, I'm gonna have to give him a call.
And I'm still on the record, I know you're moving around. Mr. Roberts, you're asking for this because you have information that exists or that you want the information if it does?
It does exist according to the police report, according to the investigator's report. The only thing that may not exist is the last item, which is if they received any video from the Marathon gas station. So items 1 through 5, based on the police report, do exist. Item 6 may not exist.
And then the video of interrogation of Jeremiah Fisher may not exist. Is that what you said?
Oh, yes, as well as item 5. Thank you, Your Honor.
To the gentleman who just called in, what's your name?
Hello,
What's your name, sir?
Jonathan Bernard Brown.
Okay, we're off the record on Mr. Fisher's case and no Mr. Jonathan Brown. Mr. Brown, I need you to stop talking and I need you to minimize the background noise. It's very loud.
Okay,
Thank you. People of the state of Michigan versus Jonathan Bernard Brown, case 205-053. Mr. Brown is charged with 1 count of controlled substance, possession of methamphetamine and or ecstasy with a habitual offender fourth offense notice. Today set for a probable cause conference appearances.
Alexander Kirk on behalf of the people, P86282.
Good morning, Your Honor. May it please the Honorable Court, Adel Haradwala, P40095, appearing on behalf of the defendant. It's going to be a waiver today, Judge.
Okay, and Mr. Brown, can you state your full name for the record?
Jonathan Bernard Brown.
And are you consenting to having your hearing today held via Zoom on the telephone?
Yes,
Okay. And is it correct, Mr. Brown, that you are waiving your exam today?
yes,
You understand you have a right to an exam?
yes,
And that if you were to demand that exam today, the people would have to show, or demand on the date of your exam, I should say, that they would have to show at the probable cause standards that the crime that I just read off was committed in the city of Detroit, and that you likely committed that crime. Do you understand that?
yes,
And then by waiving your exam, the people do not have to show that. And you'll be sent right over to Third Circuit Court for an arraignment on the information. Do you understand that?
yes,
And knowing that information, do you still wish to waive your exam?
yes,
Did anyone force you or threaten you to waive your exam?
no,
Anyone promise you anything for you to waive your exam?
no,
Okay, I find your waiver to be freely, understandingly, and voluntarily given. If there's no objection from the people.
No objection from the people.
Okay, I will have you bound over, Mr. Brown, to Third Circuit Court for an arraignment on the information date of March 24th at 9:00 a.m.
okay.
Thank
Anything
you, Your
else?
Honor.
You're welcome, y'all. Have a good weekend.
Have a nice day, Judge. Thank you, and a great weekend.
Thank you. You're all set, Mr. Brown. You can hang up.
Okay.
Okay, we're back on the record on Mr. Fisher. Mr. Kowinski, I believe you did speak to the officer in charge.
Yes, I did. He is getting back to the precinct right now and he will look into it, or he will have someone else look into it as soon as possible, and he'll be in touch with me maybe within the next hour or even hopefully less than what he assured me.
Mr. Roberts, I know your request is for dismissal.
Yes, I am amenable, and you know that I have another case, Mr. Stevenson. If I do want confirmation from the OIC about the existence of this. It's in the police report that it exists, but if we can hear from the OIC that makes the most sense to me. I'm amenable to running Mr. Stevenson first, giving the OIC enough time to confirm the existence of that evidence, and then we can reappear on this case.
Okay, let's do that. We'll call Mr. Fisher once we get some information about the requested discovery.
Thank you, Your Honor. That's more than fair.
Thank you. And Mr. Fisher, you heard all that, correct?
Yes.
Okay.
I'm gonna step out this morning.
And Ms. New, good morning. Morning. How are you? Good, how are you? Running behind. Already. What's that? Running behind already. It's fine. It's a bad weather. Yeah, I started.
Your Honor, off the record, I do want to apologize for any time this is taken up. It's definitely not like me. It's not in my nature to not send discovery. We're really good about that sort of thing, especially when there's a motion to compel. Just usually our understanding that we go to evidence.com, all the discovery that's been uploaded, that's all that exists.
Oh, no, I didn't think that you were holding or not doing your part.
Yeah, none of us at the prosecutor's office would ever do that, so.
Now, you can't say no one would do that.
As far as
Would you believe? I know you weren't doing that.
No.
Right after you?
Yeah, no. No, outside.
Okay. Oh, yeah. Okay. Okay. Sir, how do you say your first name? Area? It was a lot harder. People in the state of Michigan versus Ariane Stevenson, 2355231. Mr. Stevenson is charged with 1 count of weapons carrying concealed. The felony commission with motor vehicle adult advisory and set for 178 appearances.
Good morning, Your Honor, and everyone in court. Peter Kowinski appearing on behalf of the people, P84448.
And good morning, Your Honor, Madam Clerk, Madam Court Reporter, Jonathan Roberts, P86428, on behalf of Mr. Stevenson, who's present in court today. Mr. Stevenson, could you please state your name for the court?
There you are, Stevenson.
Okay.
You only have one witness, Your Honor, so I don't know if that calls for a sequestration of the witnesses or not, but.
Well, if there's anyone in the courtroom or on Zoom who may potentially testify in this case, if this were to get bound over, and the Third Circuit, if you know that, then you may testify. Now's your time to log off or leave the courtroom.
And nothing from the people, Your Honor.
And nothing from defense, Your Honor.
Call you witness.
Thank you. The people call their first witness to the stand, Officer Griss.
And Your Honor, before we begin, I just want to note that I believe the officer has his report in front of him. I just asked that that be flipped over unless he's refreshing his recollection.
Okay. And he's face down, face down. Whenever you're ready.
Thank you, Your Honor. Good morning, Officer Gross.
Good morning, sir.
Could you please restate and spell your name just for the record?
Yeah, Officer Grimes, GRYS.
Officer Grimes, thank you. And I apologize if I messed that up. Are you currently employed?
Yes, sir.
In what capacity are you employed?
Police officer, Detroit Police Department, local precinct,
And how long were you employed in that capacity?
approximately 2 years.
Okay. Were you employed in that capacity on January 17th, 2023?
Yes.
On that date, were you patrolling on foot or in a scout car?
Yes, Captain.
Was scout car semi or fully marked?
March,
Were you in full or modified uniform?
modified uniform,
Were you alone or with a partner?
2 partners.
Who are your partners?
Officer Latu and Officer Greer.
Did your duties as an officer take you to 1299 Madeira?
Yes.
Is that in Detroit, Michigan?
Yes.
Is that in Wayne County?
Yes.
And what brought you to that location?
Patrolling the area.
When you were patrolling the area, did you happen to see anything?
Yes, I've seen a vehicle fail the signal from the curb, which we then conducted a traffic stop.
Okay. Upon making a traffic stop, did you make contact with the driver?
Yes.
Did you happen to learn anything about the driver?
I learned that the driver had an expired driver's license.
And how did you learn that?
That was through our lien system.
Okay, objection, Your Honor, is the hearsay.
What part of your say?
More specifically, how he's learning about the expired license. If he's learning that through lien, then the lien either needs to be entered into evidence or it's inadmissible. You're saying I to strike its prior answer as well.
Yes, actually, first of all, first thing, I'm not offering a statement. Second of all, weed is generally not discoverable information to begin with, so that's something that can't really be disclosed as evidence, anything in the lien network or anything, to my knowledge. So this is, I understand this is just part of police procedure upon learning defendant is licensed or not, or has registration or insured or uninsured, but.
So it's my understanding lien is not. I do believe this is offered to this important as far as the stop. I don't know yet, because we haven't gotten there. The question I want to know or answer to is whether or not, Officer Grimes, did you observe the lien search?
Yes, I did. The registered owner of the vehicle was not the driver at the time.
Would you conduct the search or observe the results of the search yourself?
So,
Did you observe the lien search yourself?
yes, I did.
So I'm gonna overrule the objection based off of them observing it, lien not being discoverable. And yeah, I'm going on to grounds.
But I also raised a relevance objection. I not believe Mr. Stevenson was the driver of the vehicle, so regardless of that, I don't know how it relates to Mr. Stevenson.
It's still, Your Honor, it's still relevant as to the base of the traffic stop in the first place, and we're gonna eventually get to Mr. Stevenson too.
Okay, it may be relevant, I don't know. It may have to be stricken.
We're gonna, I'll put it to you this way, we're gonna get into some very relevant stuff, so.
So for now, I will allow it, and if it comes out that it's still not relevant, I'll strike it from the record.
Yep. So, Officer Bryce, what did you do upon receiving that information?
Upon receiving that information, I also observed that the vehicle was no insurance. At that point, we're gonna tow the vehicle.
Okay. Were there other occupants in the car?
To my recollection, there was 4 occupants in the vehicle total.
Okay. During that, did you, on taking the driver on arrest, what did you do next?
So that night, I was a passenger for the scout car, so I put the passenger side. Observed my partner take the driver out of the vehicle. And then I went ahead and requested the passenger side of the vehicle.
Okay. Did you conduct any searches?
Yes,
Did you happen to find anything during those searches?
I did, yes.
What did you find?
A pistol and a scope pocket.
And a pistol in a coat pocket?
Yes, sir.
Can you recall which of the passengers had a pistol and a scope on you?
Mr. Stevenson.
Would you recognize him if he was here today?
Yes.
Is he anywhere in this courtroom today?
Yes.
Could you please point him out and identify a single article of clothing that he's wearing?
Black shirt.
Let the record reflect the witness has identified the defendant, Mr. Stevenson.
Perfect.
So, Officer Grice, did you come to learn anything about this defendant?
Yes, I learned Berlin did not have a CPL. Concealed pistol license.
Okay. Was the weapon loaded?
It had numerous black rounds, magazine, nothing in the chamber. No round in the chamber.
Was it placed into evidence?
Yes, it was.
Was there an evidence tag number?
Yes.
And no further questions?
I just need one to clarify, and you may have to ask questions. Did you say you found a pistol in a coat pocket or in Mr. Stevens' coat?
In Mr. Stevens' coat.
Okay. Any questions based off of my question? I know you're getting ready to cross, but.
No, nothing further.
Okay.
Good morning, Officer Grice. How are you doing?
Good, how are you, sir? Good morning.
Thank you. So this was a traffic stop, correct?
Correct.
And Mr. Stevenson was in the front passenger seat?
That's correct.
So he was not driving the car?
Correct.
And you approached Mr. Stevenson on the front passenger side of the car?
Yes, correct.
And now, while he was in the car, did you observe a gun?
I didn't have that.
Did you observe a bulge?
I did not.
And had you ever interacted with Mr. Stevenson before that day?
No.
So you didn't know him before this incident?
No.
But you do order Mr. Stevenson out of the car?
I did, yes.
And Mr. Stevenson specifically, because there were 2 other passengers in the back, right?
Yes.
So they weren't ordered out of the car at that time?
At that, one at a time.
And when you order him out of the car, you ask if you can search him, correct?
Prior to ordering off the car, I did ask him verbally multiple times. I appeared him to.
So let's just start with what you asked. So you did ask for permission to search Mr. Stevenson, correct?
I asked him to get out of the car, yes.
And then you asked to search him you specifically said to put his hands over his head so that you can do a pat down.
Yes, based off his actions prior to that, yes.
And he did not consent to that pat down, did he?
I don't recall, but based off his actions, I'm kind of down for dangerous weapons.
So
daring him to steal something.
Well, we'll take those in turn, officer, but specifically, did he or did he not consent to be pat down? Now, you had body worn camera on at the time?
Yes.
And you'd be familiar with that body worn camera that showed today?
Yes.
Your Honor, at this time, permission to approach the witness with what would be marked defense A for identification purposes.
No objection, Your Honor.
You see what it is that counsel is showing?
Yes, yes. Oh.
So you know.
Can you see this, officer? Yes. Stop playing. 2 seconds. Starting from second 0. You recognize the video, officer? Yes. Is this your body worn camera? Yes. Is it accurate representation of what you remember from that day? For the record, playing starting at minute 5, second 24. Stopping at minute 6, second 4. So officer, when you asked permission to search Mr. Stevenson, he did not give you consent, correct? Correct. You searched him anyway, correct, officer? Correct. And specifically, you patted him down around his coat, is that right?
Yeah, I reasonable suspicion.
Well, we'll get to.
As I reasonable suspicion, I'm not dangerous weapons.
So I just want to talk about what you. Oh, sorry.
I just can't hear. You said for dangerous weapons?
Yes.
Okay.
So specifically, after you finish patting him down, you then place him in handcuffs.
Yes.
And then you walk Mr. Stevenson to the front of the squad car.
Yes.
And then you physically remove the gun from his coat pocket.
Yes.
And only then do you ask him whether or not he has a CPL.
Yes.
I want to touch on a couple of things you mentioned during direct. So when you say semi-marked car, could you describe what that looks like?
Yeah, it's a black patrol car with reflective lettering that the instructions on.
And what is a
No
mod?
overhead lights.
And what does a modified uniform look like?
It's gonna be the green pants with the molly vest.
No further question, Your Honor.
Redirect.
No redirect, Your Honor. No additional witnesses, that is correct.
Okay. Who's off the testimony?
Your Honor, at this time, the people make a motion for a bind over to circuit court on arraignment on information. People were satisfied the probable cause standard was proven today. There was a probability that the defendant is the one that committed a crime. And based on the testimony that you have heard from Officer Bryce, the initial traffic stop was lawful because the vehicle failed to signal upon turning out of the curb. Furthermore, in the course of that stop, information that was learned was that the driver did not have insurance, the vehicle was unregistered, and every occupant was ordered out of the car because no one else could drive the car, and especially not the driver. He asked the occupant, Mr. Stevenson, who was sitting on the passenger side next to the driver, to step out of the car. And what that video revealed to us, that upon a simple request to step out of the car, Mr. Stevens became very combative when asked to step out of the car and saying, "You're not going to search me," or anything like that. He became very defiant. It gave Officer Bryce just enough reasonable suspicion to think that maybe there is something that the defendant, Mr. Stevens, doesn't want the officer to find out. And it was during the course of a pat down, he discovered a weapon, and on the course of the discovery of that weapon, Officer Bryce then learns that the defendant does not have CPL. Then at this point, people make a motion for a bind over and are satisfied the probable cause has been satisfied. We ask for a bind over and count one carrying concealed weapon. Thank you.
Your Honor, I think we have to use our words very carefully. And when Mr. Glinski says that Mr. Stevenson is acting combative, that he's acting defiant because he's refusing to consent to a search and a pat down, that runs afoul of the Fourth Amendment. For two reasons, we are moving to dismiss count one, carrying concealed weapon, and deny the motion for the bind over. So first, we have to ask ourselves, when it comes to the pat down of Mr. Stevenson, was it lawful? I think the Michigan Supreme Court makes it very clear that when you're doing a limited pat down for weapons, and this is People v. Champion, is 452nd volume of the Michigan Supreme Court Reporter, starting at page 92. When you're doing these limited pat downs, it's for the individual who was stopped, right? You need to have reasonable suspicion that that person has committed some offense, and then that person is reasonably armed and dangerous. You cannot wait to find other people in the car to create additional reasonable suspicion. It has to be at the inception of the stop. Who do you have reasonable suspicion for? I also want to note, Your Honor, this could not have been just ordering Mr. Stevenson out the car for officer safety, because as you heard, there were multiple passengers in the back seat. None of them were ordered out of the car. So it was clear that Mr. Stevenson, without reasonable suspicion, was being targeted. Now, I think you heard on cross-examination, the officer was trying to say that he saw some things that were suspicious. None of that was elaborated on. So just based off of some belief that because Mr. Stevenson is denying a pat down, that makes him inherently suspicious. To say that someone who is denying consent is therefore suspicious means that the Fourth Amendment is effectively vitiated anytime someone wants to effectuate it. That cannot be the case, absent anything else. And you also heard from Officer Grice, there was no indication of a gun, no indication of a bullet. So to say that this person is just acting suspicious and that's enough to pat down someone for weapons, even though this is a traffic stop, and Mr. Stevenson was not the driver of the vehicle, did not commit any traffic offense or violation. So that's the first prong of the argument, Your Honor. But even happening that, look at the timeline of events. What happens is Mr. Stevenson is patted down. Once he's patted down, he is immediately handcuffed. He's detained at that point. He is seized. He is then brought to the front of the squad car. He's then seized again because his personal property is removed from his person. Only then does Officer Grice ask, do you have a CPO?
All of that was not a testimony. Was it? That he was brought to the front of the car?
Yes, Your Honor.
Or was it only on the video?
Madam Court Reporter.
Were you responding? No.
Oh, sorry.
Let me walk and answer the question.
I did specifically ask those questions, Your Honor.
Okay, I don't remember, I couldn't tell if it was from the video or from the testimony that you elicited that from. I'm sorry, go ahead.
Of course. So it's only after Mr. Stevenson is brought to the front of the car, having already been handcuffed, having already been searched, patted down, having his personal property taken from his person, that he's asked whether or not he has a CPO. I think we've seen many cases like this, Your Honor, where I think police officers are putting the cart before the horse. And to do that means that they are violating the Fourth Amendment, Your Honor. You cannot seize a person before verifying not just whether they have a gun, but whether they are carrying that gun lawfully. As People v. Montgomery states, it would be like pulling over everyone who drives to see if they have a license. Your Honor, if you're a CPL holder, and if we were to bind this case over, the implication is that an officer has the authority to pat down and search you, detain you, put you in handcuffs, put you in the front of a squad car, and only then ask for your CPL. That makes no sense under the law. That makes no sense under the Fourth Amendment. And you heard from Officer Grice, there's no prior knowledge of Mr. Stevenson, so he couldn't testify as to whether or not Mr. Stevenson had any criminal convictions that would have prevented him from possessing a gun. There is no history of prior interactions to speak to. So all he can base it off of is what Mr. Stevenson says, or when he runs the lien search. But the lien search is not run until after Mr. Stevenson's already in handcuffs. And after Mr. Stevenson has answered the question. So for those two reasons, Your Honor, first, because there's no consent, and I would just emphasize that to search a passenger, you might be authorized to take a passenger out of the car, but to search a passenger, you do need consent. And that's People v. Meade, 500, third volume of the Michigan Supreme Court report, starting at page 205. Police cannot search a passenger or their effects during a traffic stop without consent. So not only is there a lack of consent, but once the gun is found, the officer is violating the order of operations that are demanded by the Fourth Amendment. For those reasons, we are respectfully asking that the one count of concealed carry be dismissed and this case not be bound over. Thank you, Your Honor.
And your vote?
No rebuttal, Your Honor.
All right, the video did provide some clarity that how I'm sorry, Your Honor. The video did provide some insight as to what happened of the stop. The key phrase was, "I'm not about to get searched," and that's what Mr. Stevenson said when Officer Grice went to open his door. And I do believe, based off of Officer Grice receiving information that the driver did not have a license, that the officers did have the right to tow the vehicle. And it's against the law for someone to drive on a Michigan roadway without a valid driver's license. Stepping out of the car, one incident. Patting down and searching an individual is a different incident. Officer Grice did not state that he patted him down for officer safety, nor did he articulate or even give these reasons. He said that he had reasonable suspicion, but never provided any of those suspicions to lead to thinking that Mr. Stevenson had a weapon on his person. And people view me, the case does discuss or talk about the passenger giving consent. That case is dealing with the backpack. This case, this defendant had his coat. Assuming the coat was on him, I didn't get testimony as to whether the coat was on his person or his lap or his arm. I don't know which the gun was found. But Mr. Stevenson was very clear in saying, I'm not about to get searched. So I do believe that Officer Grice did violate his Fourth Amendment rights based off of that video showing that he said he did not want to be searched. And there was no testimony of him having to pat Mr. Stevenson down for officer safety or for any reasonable suspicion that were articulated on the record or even shown on the video. So with that, I dismiss without prejudice for suspicion. Sorry. Yeah. Usually I'm not the one in trouble. Mr. Roberts, you have just Mr. Fisher left, right?
Yes.
Okay, so I'm going to handle this new case and then come back hopefully when Mr. West gets the information. Marcus Antoine Washington Felton is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, felony firearm. Today's the day set for preliminary examination. Appearances.
Alexander Kirker on behalf of the people, P86282.
James King, we have Mr. Washington, Jordan, P number 85229.
And you are requesting adjournment for your client.
Yes, I received a phone call yesterday from my client's father. Apparently, he's at St. John's Hospital. He was stabbed and he had surgery last night.
Okay. I'm trying to call Mr. Kirk, you have objection to the adjournment.
No, but Your Honor, I have spoken with the complaining witness in this case, who's expressed that he's no longer interested in prosecuting. So he is not. So he has not arrived today.
Okay, we'll have to be on your motion if you would like.
Yeah, and I would move to dismiss.
Okay. Madam Chair, you don't have any objections, correct? I will dismiss without prejudice after the complaining witness refuses to prosecute.
Thank you, Your Honor.
You're welcome. It shouldn't take long for you to get the form.
I'm sorry to cut
It shouldn't take long. I'm signing the form now. How do we hold it on your file? I gotta make the record. Okay. That's great. Good morning. Good morning. On the record, of the people of the state of Michigan versus LaShawn Chris Massey, 216-1451. Mr. Massey is charged with 1 count of weapons carrying concealed state set for a further examination appearances.
Alexander Kirk on behalf of the people, P86282.
Good morning, Your Honor. Alicia Taylor Cohen, P5627 on behalf of Mr. Massey. Mr. Massey, can you state your full name for the record, please?
LaShawn Chris Massey.
Okay, and what's going on with this case?
The people are not prepared to proceed at this time.
Your Honor, I'd just like to make a record. This matter is from 4/21. At that time, I did do the city of Detroit recording request for all et cetera at that time. I received a letter that it was still an ongoing investigation, so I could not receive any of the information at that time. 2 years later, this year, Mr. Massey was notified that he was charged in this matter. We have had several adjournments for discovery. I was doing the initial discovery back in, I don't know, January or something like that. They requested additional discovery because there was 4 officers that stopped Mr. Massey and his wife in their vehicle and only received video for 2 officers, not even the officers that actually approached the vehicle initially. We were here last week and again informed prosecution that they had only sent me the same discovery last week. No, yesterday, they sent me discovery again, which is the exact same discovery that they've been sending me from day one. I don't know if the court is aware, but there is a mandate for the regards to discovery that all video of all officers must be maintained while the case is being investigated and or pursued. At this time where I've not received all of the discovery and back from 21 requested discovery, and it's not good enough to say, oh, it wasn't turned over. It has to be maintained. And with people not pursuing this matter, I am concerned about my client's rights going forward, in that then they'll be able to say, well, that additional discovery you've been requesting for day one, all discovery at that point, we can dismiss or destroy because we're not pursuing at this time. But then in a year or 2, because it's already been 2 years and then we decided to bring it back, we're gonna reinitiate this case, and then that discovery will be gone, and we'll be able to say, well, we can't turn it over because it's gone. So I just need to make a record in regards to the discovery that I've received. And if the people attempt or intend to ever bring the case back, that the discovery that I requested and never received, had to do with officers Hogan and Myers, and then the officer Smith. I also need to receive Officer Tyus and Officer Shakur, and both Officer Hogan and Myers. And just wanted to put that on record, but I would ask the court to accept, the dismissal at the time. Okay. I understand why you're making a record. This is an event that people do, bring the case forward again. So I, on your motion to dismiss, yes, I will dismiss without prejudice today for the complaining witness. It says on here, people dropped the case. That's the reason. Is that the reason why, or is it because the complaining witness is prosecutor or not here? What's the reason?
People dropping it.
Okay. So that would be the people's motion. Right.
Yes.
Okay. Anything else? Nothing further that can be said. All right, you two. You're all set. Dismissal form will be about 5 minutes. We'll get you out of the hallway. Okay, Ms. New. We can go through that. Lasana, is that how you say it? Okay, Lasana Easley, the people of the state of Michigan versus Lasana Easley. He's 2355163. Mr. Easley is charged with one count of weapons carrying concealed set for preliminary examination. Appearances.
Good morning, Your Honor. Peter Kowinski appearing on behalf of the people, P84448.
And good morning, Your Honor. Emily New on behalf of Lasana Easley, my key number is 852. Mr. Easley, can you please state your name?
Everybody ready to proceed?
Yes, Your Honor.
Yes. Any preliminary matters other than secret?
No additional preliminary matters.
Okay, so is there anyone on YouTube who may testify? Okay, if it were to be bound over, now is your time to log off. And for the record, in the courtroom, there are only defense attorneys in here, staff, defendant, no witnesses or potential witnesses. Will there be an OIC?
No OIC, just the arresting officer.
Okay, all right, with that, go ahead and call your first witness.
Thank you, Your Honor. This time the people call Officer Boyce to the stand.
Okay.
Yes, ma'am.
See right here, and make sure you speak up in the microphone. We're gonna be ready now.
Morning, Officer Boyce.
Morning.
Could you one more time restate and spell your full name for the record, please?
First name Jeffrey, Jeffrey, last name Goins, Goins.
Thank you, Officer Goins. Officer Goins, are you currently employed?
Yes,
In what capacity?
as a police officer with the Detroit Police Department.
How long have you been employed in that capacity?
About 4 years.
Were you employed as of January 11th, 2023?
Yes, sir.
On that date, were you patrolling alone or in a scout car?
In a scout car,
Was scout car semi or fully marked?
semi-marked,
Were you in full uniform or modified?
modified Class C uniform.
Were you alone or with partner?
I had two partners,
Who are your partners?
Officer Mitchell and Officer Alisai Craig.
Did your duties as an officer take you to 10998 East Outer Drive at Maryland Street?
Yes, sir.
Is that in the city of Detroit?
Yes, sir.
Is that in Wayne County, Michigan?
Yes, sir.
And what brought you to that location?
Conducting a traffic stop.
Okay. And did anything happen as you were conducting a traffic stop?
Yes, I saw a firearm in the, under the passenger seat.
Oh, let's back up a little bit. Before you saw a firearm, you were in that area. Describe what you saw first.
The initial reasoning for the traffic stop.
Yes, well, I should have asked, what was the reason for the traffic? What was the reason?
Front window tint and no insurance.
Front window tint and no insurance, okay. Did you have a chance to make contact with the driver?
I did not directly speak with the driver, no.
Did you at least see the driver?
Yes.
Would you be able to recognize the driver you saw today?
Yes.
Is he anywhere in this courtroom today?
Yes.
Could you please point him out and describe a single article of clothing that he's wearing?
Yes, he's seated behind you to your right wearing the black coat with the lines.
Let the record reflect the witness has identified the defendant, Mr. Easley.
So like the, just a minute.
Okay, Mr. Easy is wearing a mask. The only person not in a suit in the courtroom. There's no objection. The prejudicial nature of being for age. Because he's clearly the only person who's not a lawyer or working for the court in the courtroom. And he also is, the main reason is he's wearing a mask. You can't see his face to identify.
Okay.
Let me, if you want me to do this, I can, another way I can do this. Your Honor, can I respectfully, was he wearing a mask at the time?
Don't believe he was, no.
Your Honor, may I respectfully ask if you could instruct everyone to remove their masks for the purpose of identification?
Sure, everyone in the courtroom, 5 seconds if you could remove your mask.
Thank you. One more time, is this person anywhere in the courtroom today?
Yes, sir.
Could you please identify him by a single article of clothing that he's wearing while pointing him out?
Yes, that's the same gentleman I just pointed out, wearing the black coat with the lines logo.
Let the record reflect the witness has identified the defendant.
No reflected.
Thank you. Now, just how close were you to the driver?
I was on the passenger side of the vehicle.
Okay. During that time, did you happen to see anything?
Yes, I observed the firearm under the passenger seat.
You observed a firearm. Or did you remove the firearm?
Yes.
Was the firearm loaded?
It had a loaded magazine in the magazine well, but no round in the chamber.
And one more time, can you restate where you found it?
It was under the passenger seat.
Was that weapon placed into evidence with an evidence tag on it?
Yes.
Did the defendant have a CPL?
No.
How did you know that?
I heard my partner ask. I observed on our law enforcement information network computer that he did not have a valid CPL.
So you got that information from the lead network, correct?
Yes.
Objection, Your Honor. This is hearsay being offered. It's an out-of-court statement being offered for the truth. The lien network is network. I don't have a copy of this lien result. So I'm objecting to its admittance. Objecting to its admittance as evidence in this case. It is hearsay.
Your Honor, this is not a statement that's being offered. This is just the lien information network, which, by the way, that's non-discoverable information. They can't really be disclosed with anyone.
I'm just curious, how is the lien report, how are lien reports or information supposed to be presented to the board?
I would imagine like any other business record. I don't know why it's not discoverable. I don't understand that argument. You would think they would just print it out and hand us a copy of the information. I don't know what it looks like. I don't know what it says.
Your Honor, it's actually my understanding that disclosing a lien information network is actually considered a felony. I could be wrong. I've only been with the office for a few months, but I don't wish to do anything like that. So.
Your Honor, there would be other ways to introduce that Mr. Beasley doesn't have a CPL. That would not, the people have this burden. This is a central issue of this examination. It is an element of the offense. So this way of introducing the evidence is not admissible. It's my argument. There could be other ways they can introduce it that would be lawful.
That's what I'm trying to figure out how.
There are other records kept by whoever issues these CPLs. They can have one of a letter from that individual, which could be a business record exception. The officer who questioned Mr. Easley, and if Mr. Easley gave an answer to questioning, that officer could testify.
But when the officer is on site trying to confirm whether someone has a CPL or not, they can't call the clerk's office to confirm. The only thing they have, I believe, my understanding is the search at the time.
I'm still going to object to it. I've never heard that it's a felony to disclose that information to the defense attorney. We're not giving it to the public or to your honor, honestly, disclosing to the court this information.
I don't want to testify, give my information, what I know about it, but based off of the officer observing the search results, so I don't want to overrule that objection. And it's been noted. Thank you.
Thank you so much, Your Honor. Just be sure it was in the lead now when you discovered that defendant doesn't have a CPL. Is that right?
Yes, yes, sir.
Did you happen to conduct any further searches in the vehicle?
I did conduct an inventory search in accordance with our policy.
Objection, Your Honor. What is the relevance of further search since he already testified to finding a firearm, which is what Officer Easley instruction?
Your Honor, this is an inventory.
I'm sorry. Oh,
let's do it. You guys have to share the microphone.
So my objection is to the relevance of this line of questioning, since the officer already testified to discovering the firearm, which is the only charge that currently exists.
Thank you. Yes, an inventory search, I believe, is very necessary to ensure officer safety and protect the contents of the vehicle. It was necessary because upon that time, the officer here discovered that the defendant is carrying a weapon. To say he did not have any more weapons somewhere else in the car, but an inventory search is still part of a routine patrol, especially if part of routine police duty, especially if evidence has been discovered and the person is about to be arrested. Then to ensure officer safety, an inventory search is necessary, and anything that may be found along the way should be admissible as well.
Firearms found for the inventory search.
Yes, Your Honor.
It may be relevant. I don't know if people may want to add charges if something else is found. I don't know. I would allow it. I don't know why it's relevant, but I will. I don't know if people are going somewhere. Are you going somewhere with the inventory search?
At this point, no, it's just more to see if there's anything else that's discovered. But we have no further questions, Your Honor.
Okay, cross.
Officer Goins, you were and you said you were working this day with 2 other partners, correct?
Yes, ma'am.
And were all 3 of you in the same vehicle?
Yes, ma'am.
And where were you in the vehicle?
I was seated in the rear passenger.
Okay. And so you did not yourself initiate the stop, correct?
No, ma'am.
Someone in the front seat said, correct?
Yes, ma'am.
So at the time of the stop, you had no personal knowledge of whether or not Mr. Easley had insurance, right?
I could see that my partner had ran the vehicle in our lien network. And there is a point where it tells you if the vehicle has insurance or not. And I could see that the vehicle had insurance.
You saw that from the back seat.
Yes.
And was the car you were in behind Mr. Easley's car?
Yes. When we conducted the traffic stop, yes.
And when you ran the tag?
Yes.
But I'll be right back. Really? I get the original?
You said you recovered the firearm under the passenger seat,
Yes, ma'am.
and if you remember, was Mr. Easley still in the car when you recovered it?
I believe my partner was getting him out just as I was going in to grab the firearm.
He was talking to him at the driver's,
Yes, ma'am.
and you were in the back of the vehicle?
I was on the rear passenger, which would have reflected the same on the traffic stop.
So you went into the rear passenger door to retrieve the gun, not the front.
Rear passenger, yes,
You went into the rear passenger.
yes,
And that was while your partner was, is that Officer Mitchell?
yes,
While
yes,
Officer Mitchell was talking to Mr. Easley?
yes, ma'am.
And at that point, Mr. Easley was under investigation for front window tinting?
Front window tint and no insurance.
Okay. And while you approached the car, you ordered Mr. Easley to roll down all his windows, correct?
Yes, ma'am.
And he initially rolled down just the first front two windows,
I believe so, yes.
and then he was ordered again to roll down all the windows.
Yes, ma'am.
And this was about 5 in the morning?
No, I don't believe so.
Do you remember what was dark out?
Yes, ma'am.
And you remember all three of you, you and your two other partners, all three of you approached the vehicle, correct?
Yes, ma'am.
Officer Mitchell to the driver's
Yes,
side, and then you and your other partner on the passenger side, correct?
yes, ma'am.
No further questions?
Just to your honor, and I'll be brief. First and foremost, how many passengers were in the car?
It was a lone driver.
Okay. I just want to be sure, you might have asked that, answered that, I might have forgotten, I just want to be sure. And the other question I have is, if your partner was questioning the defendant, what was your reason why you were on the passenger side?
That's just how we approach vehicles when we conduct a traffic stop, operating three-man. Just how, and wherever we're seated, that's how we approach the vehicle.
Then I got nothing further.
I have a couple questions. So, when did you begin searching the vehicle?
I only ever searched the vehicle after Mr. Easley had been arrested for concealed carry of firearm within a motor vehicle.
He was arrested for carrying concealed,
Yes, ma'am.
and then you searched the vehicle?
Yes, that was to conduct an inventory search prior to the tow arrest.
But maybe I'm confused. Did you observe the firearm before searching the vehicle?
Yes, yes, Your Honor.
And you observed it on the floor under the passenger seat?
It was the actual handle of the pistol was sticking out from under the passenger seat.
From the back or the front?
From the back, Your Honor.
Okay, you don't have any questions either, based on my question. Okay. Oh.
You say you observed it underneath the passenger seat,
Yes, ma'am.
the butt of the gun.
Yes, ma'am.
And you observed that after Mr. Easley rolled down the rear window, correct?
Yes, ma'am.
And he was ordered to roll down the rear window.
Yes, ma'am.
And that's because the rear window had some tenting on it,
Yes, ma'am.
and that tenting was not the tenting you were investigating, correct?
Not the rear ones, no.
But it needed to be rolled down because the tenting was dark,
Yes,
and it was dark out.
yes,
So once he rolled it down, you could see.
yes, ma'am.
Okay, and then that's when you told your partner you saw a firearm.
Yes, ma'am.
Number.
Any questions?
No, nothing from the people.
Okay, I don't have any other questions. Thank you. Okay, when the officer steps out. Any argument?
Thank you. Your Honor, at this time, the people make a motion for a bind over to circuit court for an arraignment non-information. Standard proof today was probable cause. The people believe they met their burden. What began as a traffic stop because the vehicle had tinted windows and also uninsured, ended up turning into a discovery of a weapon as the officer Rice who testified today. I'm sorry, Officer Goins. He testified today on the stand that he had observed what appeared to be the butt of a handgun. He recovered that weapon and it was placed into evidence. And it was in the lead network that revealed that defendant is not a valid CPL holder. And please keep in mind, any information obtained from the lead network, it's not a statement, it's just information from a machine. It's just a system. It's not in any way a statement. It's how the officer Goins found the defendant had no CPL and therefore had the legal right to take the weapon and place it into evidence, and therefore the people are satisfied that probable cause has been met and ask for a bind over on count one carrying a concealed weapon. Thank you.
We are objecting to the bind over on the grounds that this gun was recovered during the course of a legal search. At the time Officer Lloyd entered the vehicle, Mr. Easley was simply being investigated for tenting, which you think they would want to have left the front windows up to investigate the tenting. However, they had to roll all this windows down, so they aren't investigating the tenting. So maybe the insurance, but at that time there was nothing to do with anything that would be in the vehicle, especially the back of the vehicle that they would be investigating. The search, what constitutes a search in this case, and this is Arizona v. any manipulation of physical material that allows the police to suddenly be in the vantage point to see something, that constitutes a search under the Fourth Amendment. That's Arizona v. Hicks, very old established case law. So by ordering him to roll down the windows, if that is, though there actually wasn't testimony explaining how the officer saw the gun, but were that to be an assumption, it is not a constitutional valid, it's not a constitutional vantage point that officer was in when he looked into the back of the vehicle. As he said, they specifically ordered him to roll down all his windows so that they could look to the back of the vehicle. There's no one else in the car. There's no other reason to explain why they would want all the windows rolled down while investigating tenting, except to look for something criminal within the vehicle. For those reasons, I do not think the police or the people have established the constitutionality of the evidence that they're introducing. And for those reasons, this matter should not be found over and the charge should be dismissed.
Just for a brief moment, please note, Your Honor, that the weapon that was recovered and placed in evidence was actually during the stop, what was actually a lawful stop. observed in plain view, and that case, the gun was lawfully recovered. And just to go back to what was said originally, this was a lawful traffic stop and being one on the basement, having very tinted windows, and nothing further.
I received verification as to Officer Boyne observing the firearm and when he did, how he did it. I do believe that people have met their burden of probable cause standard. The officers did stop, the testimony did stop was based off of a tent, a tent violation as well as no insurance. And although Officer Boyne didn't specifically state why he asked to blow the window down, we have heard that during the stops, officers do that for officer safety or to see who's in the vehicle at the time when approaching the vehicle. And I don't know why, maybe during investigating intent, they have to blow the window down. That's a question of fact for the trial fact as to why, what Attorney has argued about why they blow the window down for the tent stop. I believe it was because of officer safety and just investigating who was the vehicle when they approached the vehicle. Nevertheless, when the window was rolled down, Officer Goins did say that he saw the handle of a weapon from the passenger seat from the back, and then it was sticking out. And based off of that, in plain view, he did not have to search the vehicle or manipulate anything in the vehicle to find it. I do believe that the people have met their burden of proof. So I will have the defendant bound over for bringing on the information date. Since he's out of custody, it will be March 24th at 9:05 a.m. at Frank Murphy Hall.
Thank you, Your Honor.
First, we handed served it to Bailey.
Fisher back here.
Yep. Yes, sir.
You have some news on discovery?
Oh, no, I still haven't heard from the officer. I'm gonna give him a call now, if that's okay. Robert, I'm awfully sorry about all this.
Requesting your signature and the seal.
Sure.
Also, off the record, do you know what statute they're referring to? Because I often hear that
A copy goes to state police. from
I just
the-
want to look into that.
Yes, as a matter of fact, I did.
You want to go on the record? Can I go on the record with this?
Yeah, have it off record,
Okay.
because Roberts, if you want to come up with me as well, too.
Okay, we're gonna back on the record on Jamar Fisher appearances.
Good morning, everyone. Peter Kowinski, appearing on behalf of the people, P81148.
And good morning, Your Honor, Madam Clerk, Madam Court Reporter, Jonathan Roberts, P864228 on behalf of Mr. Fisher. Mr. Fisher, could you please state your name for the court?
Okay, and we're back on the record to see whether, Mr. Kowinski, you were able to get some information from the OIC about the requested discovery that Attorney Roberts wanted. Do you have any?
Your Honor, the only information I have is that, well, the detective claims that there is some footage, body cam footage available. I'm not seeing it anywhere at evidence.com. Furthermore, the detective was very candid about me that there no longer is any interrogation footage. Apparently that's been deleted. I think they deleted after 30 days now. I'm not really sure, but my point is it's not there anymore. And furthermore, the only evidence we have are the zip files on evidence.com, and that's all I was able to send Mr. Roberts, and I've not been able to find any evidence despite doing a very diligent search by calling the OIC and checking out evidence.com multiple times. There's nothing.
And defense does appreciate the candor of the state, and we also recognize that it might not necessarily be the state specific fault. There might be some issue with DPD that needs to be addressed, but in any event, the discovery order was violated, and we would be moving to dismiss without prejudice.
And Mr. Kowinski, I appreciate your, as I said, off the record, your candor when you spoke off sidebar. It's not you that destroyed the evidence. You requested it. You did your job and provided to the people everything that was provided to you. However, I have an issue with evidence being destroyed. According to the court rules, it's not supposed to be destroyed after a case is initiated. In this case, the interrogation video specifically has been discarded based off of what I believe to be a policy of the police department for storage. Can't assume that, but we don't have the video. I do not think that defense counsel should be required to move forward without having discoveries that the police department said that they did have, but won't provide if you no longer. So with that, I'm going to dismiss without prejudice, based off of the failure to provide discoveries from the police department. Not
Thank you, Your Honor.
Yes, Your Honor. Thank you.
and I just added on the form in parentheses where it says discovery violation, I put DPD in parentheses.
Thank you. I'll try carefully. Possibly.
Yeah. Right now.
No, it doesn't. Oh, you.
Thank you. We'll get it tomorrow, so I'll have it Monday. Okay. What's going on with Terry Williams?
Terry Williams?
Yeah, he's up 10:30.
He was on Zoom.
I think Mr. Alkowitz stood in for Terry Williams, didn't he?
Yes.
Can we get a date for that?
Yes.
4/13.
Why do we? I thought it was set
It's a 230
The co-defendant
Oh, yeah.
fled. No.
They didn't have the same dates? Yeah, because it was William Welch and Terry Williams.
Did I give an exam date?
4/13 at 10:30. Yeah.
Okay.
They're both here.
I didn't even realize it's that exam.
With
You
the-
said 313.
No, 4/13.
You got 313 right here. Oh, four.
There's a discovery.
Right, they made that request. That's why you said it's. April 13th. Oh, wait. April 13th? No, Judge wrote it. He's only 3. All right, we're on the record. This is people of the state of Michigan versus Gary Lewis Foreman, 2355364. Mr. Foreman is charged with count 1, assault with a dangerous weapon, felony assault. Count 2, weapons from firearms. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, felony firearms. With an habitual offender, third offense notice today that they set for preliminary examination appearances.
Alexander Turner on behalf of the people, T86282.
Good morning, Your Honor. Maurice Davis, P 76203, appearing with Gary Foreman, President of the State Nation.
Foreman, can you state your full name?
Yes, my name is Gary Lewis Foreman.
Good morning. Are all parties ready to proceed?
Yes, Your Honor.
Ready.
Any preliminary matters?
Move to support the witnesses.
And Your Honor, just at this time, the people would vote to admit pursuant to MCL 766-11B1B. Certified copy of the defendant's previous felony charge of home invasion second degree.
Will be admitted as well as, there's no one in the courtroom other than the attorney, staff, and if there's anyone on YouTube who may be testifying in this case, now your time to log off. With that, Mr. Parker, point for it.
Your Honor, at this time, the people call Mary Tenisma. And Your Honor, may I?
Yes. Okay. Okay. Hi. Maria, MARIA. TYY.
Two Y. NIS, that's okay. NIS. Yep, IS. MAA 2A.
I'm going to swear you in.
Oh, okay, I'm sorry.
Fine, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
You can pull that door open in front of you and then have a seat.
Okay.
And you can pull that microphone and put it in your lap before you, just make sure you speak up.
Okay, right here?
Yep, you can take it off and put it in your lap or just speak it to it.
Okay.
Whenever you're ready.
Morning. Could you please restate your name for the record?
Maria Tinesville?
I want to take you back to the date of March 8th, 2021. Do you remember that day?
Yes.
Were you at or near the location of 17453 Cameron Street?
Yes.
Is that in the city of Detroit, county of Wayne?
Yes.
And what brought you to that location?
That's where I live for 57 years now.
And did something happen on that date that brings you into court today?
Yes.
And what was it that happened?
My daughter's ex was chasing her and was going after her.
And is there anybody present in the courtroom today that you came into contact with on that date?
Yes.
Could you please point out that individual and identify the article?
Gary Foreman, red pants and a white t-shirt.
Your Honor, let the record reflect the identification of the defendants. And so you said and who is the defendant to you?
This is my daughter's ex son's father.
And you said he was chasing her,
Yes.
your daughter?
Yes.
And where was the defendant chasing your daughter?
Down the street with a car.
And where were you when this was happening?
In the house.
You ever come outside that?
Yes, I did.
And what happened when you exited the home? Your home?
Him and my daughter were arguing and the kids were crying and he was going after my daughter.
And did you speak with the defendants at all?
Yes, I did.
What did you tell them?
But we had an argument. I told him to get from in front of my house. He was not wandering around my house and to leave.
And did the defendants leave your house?
No, he did not at that present time.
What did the defendant do?
He argued with me and threatened me.
And when you say threatened you, how did he threaten
He told me he was gonna kill me.
you? And did you believe that he could?
Yes.
And did the defendant do anything else?
He went to his truck, which he had 2 other kids in the truck with him. And he reached up underneath the seat, the driver's seat, and pulled a gun from underneath the seat and pointed it at me in between the door and the truck. And he said, if I didn't have my kids in the car, I would kill you, but I will be back. And he got in the truck and he left.
Okay, so we'll just go back to that. So did you describe the gun to me?
With his little gun, short black, like not a revolver, like revolver, it just like a flat black gun.
So a small handgun?
Like, yeah, like a handgun. I'm not good, I don't know different guns.
And do you know what color it was?
Black.
And you said the defendant pointed it at you.
Yes, he did.
How far was the defendant when he pointed the gun at you?
I was on my steps at the time, at that particular time. Maybe 15, 20 feet.
And how many times did the defendant point the gun at you?
Just once. Just once.
And did he make any statements when he pointed the gun at you?
Yes, he told me if he didn't have his kids in the car, he would have killed me and he will be back.
And how did you feel in this moment?
Scared.
Were you scared for your life?
And my grandson and my daughters, yes, all the kids around. I have a lot of children to stay at a lot of grandkids at my house at all times.
And what happened after that?
he left, and I believe I called the police, somewhere along the line, I called the police.
I have another question.
Now, you stated that Mr. Foreman was chasing the daughter when you first saw him, is that correct?
Sort of, kind of, yeah.
Sort of, not really.
Yeah.
They were just going back and forth having arguments. is that what
No.
you're saying?
No, he come flying down the street.
Okay. And where were you standing when you first
I
saw
was
him?
in the house. I heard the vehicle.
You heard the vehicle. Did you look out the window?
No, my phone was going off. Horrible. And I ended up answering it, and it was my daughter. And she said, Gary's chasing me. Can you please come outside, help me?
I'm not asking about anything that your daughter said. Okay?
But you asked me what
That's
happened, and I'm telling you.
That's what you're starting to say. Daughter said.
Based off of,
Hearsay.
unless you have, well, no, it's hearsay.
And at some point you walked onto the porch, is that correct?
Yeah.
And you stated that Mr. Foreman, he was seated inside of this vehicle.
No, I never said that.
Was Mr. Foreman inside of this vehicle?
No, he wasn't. He was out in the middle of the street.
Okay. And at some point he got back into the vehicle, is that correct?
When he was getting ready to leave after he pointed the gun at me.
So you're saying he got into this vehicle and then grabbed the firearm?
He didn't get in, he didn't sit in the seat, he opened the door and reached up underneath the seat, pulled the gun from underneath the seat, and then between the door and the, how do you say it, when the door was ajar, he was in the doorway in the truck. Like if I was to open this up right here and do like this here, the stand right here, that's how the car was.
You're saying that
Truck.
For the record, you have to say, so the court reporter.
I'm sorry.
Because if you're reading it, people can't see that.
Okay.
So, I knew witness, we all agree, let me know if this is accurate. She opened up the door where she testified in the witness box, leaning out, pointing with her finger.
I agree.
Is that accurate? Or-
Yes, that's right, what you did. Now, how would you see where Mr. Foreman grabbed the alleged gun?
I'm sorry.
How would you see where he grabbed the gun from?
Because I was outside right there,
You were approximately 20 feet away from them, is that correct?
approximately, I don't know the exact measurement, but it wasn't far, it was very visible.
Now, was anyone else witness this?
I don't know, there was so much chaos going on, I can't speak for somebody else.
Now, you admitted that you don't know a lot about firearms, is that fair to say?
I know a gun when I see a gun,
You should state that you don't know a lot about firearms, you don't know different kinds or anything like that.
No.
Is that
long,
correct?
short, black, green, yeah, I could tell color and if it's a gun or not.
You only saw this firearm for a few seconds, is that fair to say?
No, it wasn't a few seconds, it was more than a few seconds, he stood long enough to tell me he's gonna kill me and he'll be back after he gets done dropping off the kids.
Then he set the gun away, put the gun away and got into the car.
I don't know what he did. He got in the car with that. I don't know where he put it when he got in the car.
I mean, actually, very quick, but he put the firearm back into the car when he got into the car, is that what you're saying?
He took it with him.
He left with it.
Yes.
Now, you don't know the different types of guns, you said, you know, if it was a revolver or just describe it as a flat gun, is that correct?
Correct.
Okay. You stated that you're not good with guns, is that correct?
Correct.
Okay. So you can't say what kind of firearm it was, is that?
No, but if I seen some pictures, I bet you I could tell you what kind of
Now,
one.
answer the question for me.
I am answering the
Answer the question
question.
that I asked. You can't say what type of firearm it was, is that correct?
I don't know.
Can you tell me what type of firearm it was?
I don't know. If I seen a picture, I could.
As you sit here today, can you tell me the type of firearm it was?
No.
So the only thing that you really can say is that it was a black gun, is that fair to say?
A gun is a gun.
Is that fair to say?
No.
You can tell me something else about it?
It was a gun. I seen the barrel. I seen him have finger on the trigger. I seen a gun.
The gun was never fired, is that correct?
Thank God, no.
Okay, you can't say it had the ability to fire a projectile, is that correct?
No, come on now.
You can't say that, is that correct?
No.
In fact, you can't say whether or not it was a real fire.
Yes, I can. Yes, it was a gun. A gun is a gun.
Can you tell me whether or not it was a real firearm or a
It
real?
didn't have no orange on it. If it had an orange on it, it would have been a real gun.
It's possible that it could have been a replica firearm that didn't have any orange on it, is that correct?
No, it was a real gun.
How do you know that?
I don't know. I've seen real guns before.
Someone
I've
who
seen
admitted-
guns.
Someone who admittedly doesn't know much about firearms, considers telling me that the firearm you saw was a real
If I
firearm.
don't know about cars, if you tell me the car is a car and the truck is a truck, a gun is a gun.
I know the question.
Okay, thank you.
Any other witnesses? No further witnesses from the table.
Right here is the report, photos, and kind of state, make sure you speak of it. Okay.
Thank you. Please state your name for the record.
Angela Marie Francisco,
You spell your last name for the court report?
T is in Tom, Y, and it's in Nancy, I, S is in Sam, and it's in Mary, A.
Okay. Angela, you know an individual by name of Gary Foreman, is that correct?
Yes.
Okay. How do you know Mr. Foreman?
My son's
Since your son's father. How long have you known him? I want to direct your attention to March 1st, 2021. Did you have contact with Mr. Foreman on that day?
Can't really explain that on March 21st, but I wouldn't know.
You remember an incident involved your mother and the confrontation between Mr. Foreman and your mother?
Yes.
You do remember that incident?
Mom.
Okay, you remember that incident around March 1st, 2021, okay. Now, you were outside the entire time, is that correct?
Not the entire time.
You saw the two of them going back and forth and arguing?
Yes.
Okay, you never saw the fire. And you, did Mr. Foreman, Mr. Foreman stayed in his car the entire time?
No.
He got out?
Yeah.
He said some things to you, and you said some things back to him, is that fair to say?
He was arguing with my mom.
He's arguing with your mother, okay, you watched this and you saw the two of them go back and forth.
Yeah.
Did you say anything and tell them to calm down, would you?
I got my kids in the house away from the conflict, and that was it. Like, I told him he needs to leave, but not too many words were exchanged between me and him while he was at house, more so on the phone. But the conversation, the argument between him and my mother was more so sensitive.
Did you watch him as he finished the confrontation with your mother and get back into the car and leave?
Yes.
Okay, you saw that part of the things, right?
Yeah.
You didn't notice anything out of ordinary at that point, is that correct?
What do you mean?
You didn't notice any type of threatening behavior in his weapons at that point, is that correct?
Verbally, he did say he will be back, he don't give a fuck.
Okay, but you can see his hands, like, was he waving his hands around?
I mean, when they were arguing, yes, his hands were up and down, but he was standing, my car was one way, his car was the other way, he had his car door open, so he was between the car doors, so as far as seeing anything, no.
Okay.
Great job. So to clarify, you said you saw the defendant between his car door. And where were you at this point?
I was in my car, in my driver's seat of my car.
Was the driver's side, was the door between you and the defendant?
So he was coming up the street, I was like, say, so leading off the street. So my driver, or this way, his door was this, on this side.
So was the door, when the door was open, did you see all of the defendant or was some of the door blocking?
When he was behind the door, but when he walked towards my mother, I could see the full of his head.
And did the defendant make any threatening statements?
Yes,
Do you recall any of those statements?
yes. He said, "You white bitch, I will be back. I don't give a fuck, and I'm gonna put you on top of your father." Which is for my mother's father is deceased.
Your mother's father is deceased.
Correct.
And you took that to mean that he would kill.
Yeah.
Jason Lee.
Cross. I have no further questions.
you redirect?
No, that's the no, the witnesses, Judge.
And press? Press? Argument?
Your Honor, at this time, the people would go to bind over on all counts. Those would be count one, assault with a dangerous weapon, count two, weapons, felony, firearm, count three, weapons, firearm, possession by the felon, and count four, weapons, felony, firearm. So we heard from the first witness, she came out of her house during an argument between her daughter and the defendants. At some point, she then engages with the defendant and they get into an argument. The defendant then went back to his truck and pulled out a firearm, which the witness described as a small, flat, black handgun, pointed it at her chest, making several threatening statements, including stating that he would kill her if he didn't have his kids in the car, and that he would be back once he dropped his kids off. As the witness testified, she feared for her own life, she feared for the life of her daughter at this point. We then heard from her daughter who, while she was not there for the entire incident, did not see all of it. She certainly heard the threatening statements that were made, including that the defendant would put her mother on top of her mother's father. People believe that they've been the burden of probable cause of the side over treatment.
Judge, we have someone who testified, she admittedly doesn't know much about firearms. Yet she sits here trying to tell the court that she was assaulted by a firearm. She can't say what kind of firearm it was. She can barely describe it. The firearm was not recovered. It has not been shown that my client was actually in possession of the firearm. We had her daughter Maria who testified that she witnessed Mr. Foreman and her mother arguing, and she never saw the gun. She witnessed his hands going up. She witnessed them, the two of them going back and forth. She heard threats that were made, but she never saw a firearm. She saw him get back into the car and did not see that gun. Additionally, the people's witness testified that she can't say whether or not the firearm was in fact a real gun. Another point, my client is charged with felon in possession of a firearm. Home invasion, second, is a non-specified offense unless it's shown that the dwelling that was broken into was in fact occupied. There's been no such evidence presented, so I'm asking for a dismissal of confiscation.
Yes, Your Honor, just simply that, as the mother testifies to, she was quite confident that she saw a handgun. And she could describe it as a black handgun, small, flat, and the lack of knowledge of specific types of guns is not, somebody is entitled to point a gun at somebody else. That would reiterate our request that this case be found over to the
What about the defense counsel's request to dismiss on the certified copy for home invasion second?
Your Honor, pursuant to NCO 76811, the certified copy of conviction at this stage is sufficient evidence of that conviction. As long as it is certified.
Okay, so I'll start with, so MCL 766.11B, correct? It says the rules of evidence apply to preliminary examination, set the following are not excluded. Rule of hearsay and shall be admissible at the preliminary examination without requiring testimony of the author or keeper of records or any additional foundation for authentication. It will be B, which is a certified copy of any written or electronic order, judgment, decree, docket, entry, register, fact, other record of any court or government agency of the state. I already know, Mr. Davis, you're standing up with your objection to the bind over risk with that count. Go right ahead.
I'm not saying that the certified record can't come in, what I'm saying is the offense is not a specified offense. There are specified offenses in which firearm rights have to be restored after 5 years by a court. You have non-specified offenses in which your firearm rights are automatically restored after 3 years. A specified offense is an offense that involves a firearm, involves violence against the felony, that involves violence against a person, or it could involve breaking and entering, burglary into an occupied dwelling. What was presented does not show that there was burglary into an occupied dwelling, just shows it just shows that it just shows that my client was convicted of home invasion second degree. It doesn't meet the specified offense.
You're saying home invasion second doesn't show that something broke, so they can bring it to the house.
Occupied.
Mr. Griffin? Home invasion second specified felony?
I do not have an answer on that question, but I'm looking through the elements of felon possession, non-specified.
I'm looking too. Don't mind waiting.
No, I don't mind with it.
So I have here says that specifies the felony, is a felony in which one or more of the following circumstances exist. An element of the felony is the use, attempted use, or threatened use of physical force against the person or property of another, or that by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. The element of that felony is unlawful, less than the felony is burglar of an occupied dwelling or breaking and entering an occupied dwelling for arson. So the question is, home invasion second.
That's one.
Just want to make sure specified felony definition is correct. Home invasion 2. No, first 3.
Mind if I step out for a second? I've got a client. Okay.
Mr. Carter, you want the first three versus the second three?
I have a point of one.
The home invasion second degree, I haven't printed out.
Oh, you got it?
Yeah. So let's deal with the specified. First, Mr. Carter, is it, are you agreeing with council or are you disagreeing with this is not a specified zone? Or
Even if it is a non-specified felony, I'm having a hard time figuring out what's the objection. So the only difference is the smaller time frame. I find located. So
we'll count three, right? Attorney Davis?
Correct.
So count three states under the information here that Mr. Foreman did possess a firearm when ineligible to do so because he had been convicted of home invasion second degree, a specified felony, and the requirements for regaining eligibility had not been met.
I can explain to you about it. So I deal with a lot of firearm restoration. Someone calls me about a non-specified offense, so the gun rights are already restored after 3 years. It's automatic. If it's a specified offense, you have to wait 5 years from the date that you finish all the requirements, and then you have to petition the court for restoration of the firearm rights. So a person convicted of a non-specified felony can't be charged with being a felon in possession of a firearm after 3 years of past. Their rights are already restored. So in this case, he's charged, he had a conviction for home invasion second degree. That's a non-specified felony. 3 years, more than 3 years have passed, so his firearm rights will be restored. So you can't be charged with felony possession.
Your Honor, if I may just check that to see if all the fines were paid.
That's what I'm looking at. And I know we only know this for being a prosecutor. So he has a balance as of March 6, 2023 for $318. So this case, that my understanding is that it's not closed, that it's still considered, this could be used as still an open case and not closed because he hasn't finished paying for done what he needs to do condition wise. Basically, money hasn't paid.
He went to prison and completed his term in prison.
Mr. Kirk, what were you going to say?
Just simply that part of the gun rights being restored are that all fines are paid. Less than 3 years have passed, and all fines are paid on the underlying felony.
So really on a technicality, the $318 is why I'm not going to dismiss the charges. Mr. Davis, you have a very good point here, very good argument. But technically, because he still owes on it, it's not closed, and his rights are not restored because of not paying. Even though you went to prison. I'm just following what the law says. I researched, I was once dismissed based off of the argument, but because you guys still have fines paid or to pay, I can't. Right now, you have $218 on that case. So back to the felonious assault. And Attorney Davis, you called Ms. Angela Heinzman. Testimony was a little different when it came to the gun. However, it's not enough to dismiss based on the probable cause standard. And Ms. Maria Heinzman testified that Mr. Foreman were near her house and there was an argument, and that it said that he was gonna kill her. He went to the truck, reached for something and pulled out a gun and said, if I didn't have my kid there, I'd kill you, and I'll be back. And then it was just pointed once. She described it as short, black, and little and flat. She said that she wasn't very familiar with guns. I don't believe you have to be a gun expert to know that a gun is being pointed at you. She specifically said she could see the orange on the gun. She was of the belief that it was a real gun and that she feared for her life. So with that, I do believe people have met their probable cause standards. I will have the Foreman bound over on all 4 counts. Information will be March 24th at 9:00 a.m. in Frankfurt College.
Thank you.
Anything else for the record?
No, nothing else.
Yes, sir. Wait outside for the attorney.
Got me there. I was confused for a minute. I had to go back to my days when I worked warrants. Okay, we are on the record. This is the people of the state of Michigan versus Lamar Eugene Williams. No. Yes. we
Yes.
have 2 Williams. Lamar Eugene Williams, 2056610. Mr. Lamar Eugene Williams is charged with 1 count stolen property, receiving and concealing a motor vehicle, 2nd or subsequent offense notice. Count 2, motor vehicle unlawful driving away with a habitual offender, 4th offense notice. Today, today's set for preliminary examination appearances.
Alexander Kirker on behalf of the vehicle P 86282.
Good morning, Your Honor. Kenneth Waldron on behalf of Mr. Williams, P7819.
Attorney Walburn, you have attempted, I know, from previous discussion, to contact your client, is that correct?
Several times, in fact, less than an hour ago to a couple of phone numbers. They all go to voicemail, and one of them identifies themselves as Lamar, so I kind of think it's a good number. There have been numerous no-shows here. Although I think he did show up once.
He did, February 24th, so we know he is alive and well, and he knows how to zoom in, and I did give him a date. And he has decided not to appear, call or answer your calls, or call you to let you know why. He's not here. So, anything from the people?
People would move for cases.
I would normally do a personal, because of the state of here, it's going to be a $5,000